the Governor General, in deciding to promulgate the SI, acted outside the scope of his authority as conferred by the provisions of the Public Safety Act, in that the trigger for making a law of this nature is that he must be satisfied that there's a risk to public safety caused by some risk of civil commotion. And again, we say that there's nothing, in fact, nothing that happened or that was likely to happen that would have given rise to any civil commotion, which would have then entitled him to do as he did.
If the government does not renew or extend the SI in any kind of way, will the court still be minded to hear this case, given that it will then become academic?
Well, what the mind of the court will be known when they pronounce upon it. There will certainly be arguments both ways. Our position will be that there is benefit to be had in the courts defining the circumstances in which powers of this nature can properly be exercised. The government will, of course, say that there isn't much value to be had in that, and there's no risk, no practical risk of this thing happening again. So there's no point to it, and it's a waste of time. Those arguments will be put and will be fully ventilated. As to what the mind of the court is, we will learn of it when it's pronounced.
For us, it is important to make it abundantly clear to the Prime Minister that we will not stand by it, that Belizeans on a whole are outraged by the very idea that we can no longer visit parts of our country. So our objective is one that, as what the legal advisor said, is to challenge the law, and hopefully we can get a ruling that can better define when a government can make pass certain SIs preventing people from going in certain areas under certain circumstances.